Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Hello. Today we're going to discuss magistrates. Now, magistrates sit in the magistrates' court, and England and Wales is incredibly unusual in that most criminal cases are dealt with either by lay magistrates with no legal qualification or by legally qualified district judges in the same court. I'm joined by Rob Allen and by Robin Fenwick, who is a magistrate for 6 years, and by Dr. Kate Leader, who's been researching lawyers' attitudes to magistrates with her colleague, Dr. Lucy Welsh.
So, Penelope, you actually yourself sat as a magistrate about 15 years ago. What do you think qualified you to sit in judgment on your fellow citizens?
Really practically nothing, apart from an interest in justice. I had worked myself as a radio producer and done some discussions about justice and just sort of thought it was an interesting thing to do. But magistrates who sit in judgment in criminal magistrates' courts are not legally qualified. I mean, some of them are, but they don't need to be. And I certainly wasn't. And also, I frankly didn't know much about the justice system or about the kind of people who appear as defendants in the magistrates' court. What about you? Because you've been in justice for a long time. Have you ever been tempted to apply?
I haven't actually, and I was thinking why that might be. I have been tempted to apply to be on the parole board, which I guess is about getting people out of prison. I think I'm more comfortable with that role, perhaps, than acting as a sentencer that puts people in prison.
I totally understand. And I have to say, when I applied to be a magistrate, I don't think I thought through in any way that I would have the power with others to send people to prison. Robin, why did you apply?
I think I had a fairly old-fashioned idea about public service. I discovered in my mid-30s that I was quite interested in justice. I think if I'm really honest, I think I probably had some sense that it would involve being important in the community, which makes me feel bad, but I think that probably was part of it. But I saw an advert in the local paper, and being the sort of person who read a physical local paper at the age of 32, I guess I probably was in some ways quite predisposed to that sort of civic role.
And amazingly, 32 is actually a young magistrate.
When I stepped down as a magistrate, I was still a member of the young magistrates group aged 40.
Kate, can I ask you, is it common outside the UK or England and Wales for people with no legal training, in effect, to act as criminal judges?
No, it's not common. So you have examples in South Australia. You have a limited role for what are called justices of the peace to do something similar. And then you also have some layperson input in criminal process in Scotland. But generally speaking, in sort of common law jurisdictions, it's a relic, if you like, of an older time when it was much more common for people who weren't legally qualified, often from distinguished backgrounds, to kind of sit in judgment, gentlemen, whatever it is. And sort of over the subsequent hundreds of years, this kind of role has largely been done away with.
And in your latest study, you asked criminal lawyers what their views were of lay magistrates. And what did you find were their greatest concerns?
I think the biggest ones that came out were lawyers perceived that magistrates didn't know the law, basically. And they felt they also didn't seem to understand the way in which criminal cases are dealt with. That was sort of one main thing. And then the second thing was communication. So lawyers perceived magistrates to sometimes be not very good at talking, particularly to defendants. There was a perception that the magistrates could be high-handed, paternalistic, talking to defendants like they were naughty children, things like that. So there were concerns about the tone of magistrates as well as what they didn't know.
Robin, were you aware that lawyers kind of were pretty negative in their view of magistrates when you were sitting as a magistrate?
Well, I think a lot of magistrates hearing what Kate just said will be pretty sad because, in my experience, magistrates do want to do well. They care about the standards. And there are very few direct channels of communication where a magistrate might receive that kind of feedback. I think many magistrates will not be completely surprised, as some of the sentiments that Kate outlined fit very much with what was said in public by a number of barristers in 2022, when there was that brief rise in sentencing powers. Magistrates were briefly allowed to sentence people for 12 months, and quite a few of the sentiments that Kate just expressed were voiced back then.
Just to give a bit of context, we started looking into this precisely because we felt that there were sort of anecdotal stories being told on Twitter and elsewhere that suggested that there was this negative perception. So we're not saying this is the truth about magistrates. We're saying this is what some lawyers think about, and it's worth exploring why.
Robin, I mean, do you think those critiques are fair? I mean, it seems to me that obviously magistrates aren't legally trained. In a sense, they're not supposed to know the detail of the law. I was more concerned about the communication one because I'd sort of thought that as representatives of local communities, that would be something lay magistrates would be better at, perhaps, than judges, because they are supposed to be more like the people that they are dealing with. What's your view on that?
I think the efficiency and the tone of any court on any given day is predominantly set by the presiding justice, the magistrate who sits in the middle chair, who speaks on behalf of the whole bench, and to some extent the legal advisor. And the process for appointing presiding justices, it is a reward really for length of service. So in the 6 years that I was a magistrate, I still, when I left, had not been offered the opportunity to apply to be a presiding justice. And I think presiding justices are appointed very much if they're kind of compliant, conforming, tend to be higher sitters. So they're more experienced. And
You mean who sit more often?
That's right. So the minimum number of sittings is 26 half days a year. As somebody in full-time work, I tended to bump along that level. Other people have got much more time, and they're likely to be older. They're likely to be more comfortably off. And those are the people who are most likely to be speaking on behalf of the whole bench. And so some of those things, despite the best efforts of things like the Equal Treatment Bench Book, which is a giant tome on how to be respectful in communication, among other things, some of those attitudes, I think, do unfortunately creep through.
Kate, you're saying that they communicated poorly. The lawyers, did they give any kind of examples, or were they at all more specific about what they thought was wrong with that communication?
Yeah, so I think the examples we got were that the chairs perceive themselves to be judges or akin to judges. So they would talk down, if you like, to a defendant.
Be patronising, as it were.
Yeah. And then I think the other thing that came up was a real concern in youth courts, that idea about them talking to them like they're naughty children, saying things like, get your hands out of your pockets, things like that they didn't perceive to be appropriate. But I do think one thing that's worth thinking about is so much of this raises really interesting questions about status, anxiety, qualification. So is it that these people are being patronising and paternalistic? I'm sure they could be, and I'm sure they probably are to some extent. But is it also that they are behaving like they shouldn't, behaving like they're lawyers when they're not? I think there's an interesting kind of thing to reflect on there, what it is that's actually lawyers are finding difficult to deal with.
Robin, any patronising behaviour?
I think this has got better. In my third ever sitting, when my training was still very fresh in my mind and it was drilled into me that I must not speak on the bench, I remember sitting with a bench of two older, very affluent magistrates. And the presiding justice decided to launch into a defendant to tell them that they needed to get their life together. And that sort of homily went on so long and was so filled with invective that I ended up turning to the chair and saying, somewhat above a whisper, you need to stop, you are not speaking for the whole bench. And my goodness, the trouble I got into for that. But those attitudes, I think, were definitely more prevalent at the start of my time than at the end. And oddly, I think that is in part because there was a real kind of modernization of the technology that is used on the bench. And as things like iPads and laptops were introduced, there was quite a churn of presiding justices. And I think over that period, we lost some of the people who exhibited some of those more strident and less empathetic attitudes to people whose circumstances they just had no familiarity with and couldn't possibly imagine.
I'm glad to hear it.
Kate, in your study, I think you found that lawyers on the whole appearing in the magistrates' courts preferred it when there was a district judge dealing with the cases, so a professional judge who, on their own, decide on guilt and innocence without any lay magistrates. Why do you think lawyers were more comfortable with that? Were they all right about there just being one person dealing with it?
I think the answer is actually kind of yes and no. They sort of said that they preferred district judges, but actually there were significant times when they preferred magistrates. So I think they themselves think they prefer district judges, but when you listen to what they say, it's a more complicated picture. So when they talked about why they liked district judges, is they felt that they could, I suppose, put their legal knowledge or their analysis into practice. They could be certain that they felt that the outcome would be more consistent. They felt that the judge would understand, and they would be able to kind of get through things very quickly. So efficiency was a huge part of it. District judges, they say, could deal with the whole list incredibly quickly, whereas magistrates were far slower. They sort of said that when you had a bench of magistrates, you had to sort of change your approach. So, one of them talked about with magistrates, you could try a sob story, but with the district judges, you'd get no shrift. You wouldn't be able to do that. But at the same time, on a strategic level, there were a number of times lawyers said they preferred a bench because the benches were more likely to give decisions that were perhaps not expected that could benefit their client. So from a kind of partisan client-based perspective, some of them sort of talked about preferring a lay bench.
And just to say, when it comes to these decisions about bail and remand, and obviously this is whether somebody is free in the community or have to stay in prison pending their trial, the charity Justice actually did a big observational study of magistrates' courts about these decisions, and they found that actually district judges were a bit harsher about those decisions. So, again, it's tentative because the numbers were not that great, but it seemed to be that a district judge was a bit more likely to send someone to prison pending their trial.
And I think that's something that, again, brings up a kind of contradiction because lawyers in this small study and historically have complained about the magistrates' courts being the police court, saying that magistrates have a reputation for sending people to prison, for being very pro-police. But actually, magistrates are less likely to send people to prison and give shorter sentences. So there's a perception that magistrates are pro-police, but it's not supported by the evidence. And the lawyers themselves saying they preferred magistrates for their client would suggest that on some level they seem to know this.
Robin, what do you think? Say you were a defendant in a criminal case. Would you prefer, do you think, to appear before a district judge or before a bench of magistrates?
Well, I think what you want to know is that the person handling decisions around your liberty or your driving license or your financial freedom or where you can travel in your town or who you can talk to, is that person competent, capable, and serious? I genuinely don't know what I would choose. And I think it would be fascinating to conduct an experiment in a courthouse somewhere to allow people who've been charged with the least serious offences, summary offences, to elect to choose, would you like a district judge or not? It'd be fascinating to see a breakdown on how people who are privately represented versus people who choose the duty solicitor who's available on the day versus people who choose not to be represented at all, to see the choice that they make. I would love to see that.
So at the moment, the position is it's random, if you like, for defendants. They turn up in court, there may be a district judge on, there may be a bench of magistrates. They have no choice in the matter. Is that right?
There's been a listing decision made behind the scenes. So where a case, for example, might rely on a point of law, that might be more likely to go to a district judge, but also you have to balance efficiency. So in my time as a magistrate, I dealt with many, many cases of common assault or theft from a shop, but I also dealt with a case as part of a bench as to whether or not somebody should retain their pilot's license. I dealt with a case as to whether somebody had illegally shod a horse, whether they had undertaken illegal farriering. Cases end up going before lay benches that would perhaps be better suited to a district judge. And I understand why some advocates want the system to be as predictable in its outcomes as it can possibly be. They're trying to gain the most advantageous result for their client. But I think it is inherent in the lay magistracy system that you will get different people bringing different perspectives to a case, which may bring different interpretations and different outcomes. And that's kind of desirable. It's what the system is set up to do.
Kate, what about you? If you were in that situation, not knowing the personalities involved, what would you choose?
I think it's worth pointing out that a lot of this comes down with magistrates to the quality of the legal advisor.
Can you explain that?
Sure. So lay magistrates, they don't have legal qualifications, but they're advised on the law by a legal advisor who's specifically trained. So in that respect, that's why it shouldn't matter that they're not legally qualified, because they'll be advised by that legal advisor as to what the law is. So the legal advisor's quality is really critical, I think, to the quality of the overall justice you get from lay magistrates. And that certainly came up in our research. Lawyers consistently said that, and they said that legal advisors' quality was variable. So I suppose the first thing I'd say is I would hope for a very, good quality legal advisor. But I think I would probably plump for the lay magistrates. I think if I was a defendant, it seems to me, based on the little information we have, that magistrates are more lenient, potentially more lenient. And that's certainly a study I would love to undertake in the future, is to really look into this more specifically.
And just to clarify on the legal advisor, this is what used to be called the clerk to the court, isn't it? And they actually sit in the court and are involved throughout, if necessary, intervening with the magistrates to explain things. Is that right?
Robin?
Yes, and they also have an enormous influence outside of open court. So in my experience, the legal advisor's greatest influence is in the part of the process where the bench have retired, they've gone away to consider an outcome. The legal advisor is invited back into the retiring room, and in that moment, the legal advisor's influence can be incredibly significant. And that is not happening in open court, and that has troubled me for quite some time.
I mean, Robin, you actually resigned from the bench after sitting, I think, for 6 years, which quite a long time, but for a magistrate, not necessarily a particularly long period. What led you to quit?
There were a few things bubbled up together. So I had some concerns about changes that were made to victim surcharges. They rose very substantially a few years ago.
This is money that you have to order defendants who are convicted to pay a sum to the victim, or is that right?
The explanation that is given is it's money that goes to fund services that support victims of crime. And one of the real problems that I had was that I couldn't find out where that money went. And I came away with a real suspicion that it was just general taxation being levied on the sorts of people who appear before magistrates' courts. And that meant that it was just a form of taxation against some of the worst off in society. So I had some real questions about that, and I just couldn't get any answers. I had been sitting in what's called the single justice procedure a few times, where magistrates do sit alone with a legal advisor and deal with cases such as truancy, television license avoidance, and things like that. And there'd been a few cases where I had tried to push back and say, actually, do you know, the mitigation in this is so strong that I don't think it's in the interest of justice to convict, and had really kind of locked heads with a legal advisor who was obviously very concerned about recording sort of anomalous results, and argued with me at great length that I had to convict. And so I'd had a couple of experiences of trying to ask questions about things and just getting nowhere. And then when the cost of living crisis hit, I could just see so clearly that we were going to see a rise in energy companies coming to court to apply to install prepayment meters, and we were going to see a rise in shoplifting. And I was just very concerned that there was going to be a sort of uncritical acceptance of this rise in cases. And I started asking questions about whether these things were appropriate, and just got absolutely nowhere. And so I guess the challenge was, I couldn't stay in my lane. I became too concerned about where is our caseload coming from, and are the results that we're recording appropriate? And, a senior magistrate said to me at one point, look, if you feel you can't apply the law, the only thing you can do is resign. And I do accept that. It cannot be the case that magistrates can sit on a bench and say, well, the law says this, but I'm not going to apply it. But I do really regret that there is no forum for magistrates collectively to have the sorts of conversations that led to ultimately senior presiding judge suspending the listing of those cases. Because around energy company warrants, there was a lot of press coverage. And it's a real shame to me that we couldn't have had that conversation inside the system. The media had to get involved to make that happen.
So can you explain that a little bit more? So this is people appearing in front of you having not paid their energy bills.
If only people were appearing in front of us. So a representative of the energy company would come to court with a list of addresses and some assurances that some checks had been done, and we would approve en masse warrants to allow those energy companies to then go and, if necessary, break into those people's houses to forcibly install a prepayment meter, where a person may have to physically take a token to their local newsagent and put £10 on their meter, take it back, plug it into the meter, and then they've got £10 of electricity. So it's a more manual process. It tends to be households that are much lower income that have them. And it used to be the case, it's no longer the case, that the electricity delivered through those meters tended to be more expensive. And I was deeply uncomfortable that we were approving these lists en masse and that we had no real way to interrogate whether there were, for example, vulnerable people living in those homes. And so I became very worried that I was going to be required to sign off on these warrants. And I just felt, this may be very pompous, but every time I went into court with a folder, and on the front of the folder was the judicial oath that said, I will do right to all manner of people after the laws and usages of this realm without fear, favour, affection, or ill will. And I just kept looking at that folder, and I just thought about the energy company warrant process, and the two just didn't compute.
I mean, Robin, you gave evidence to Parliament about this. They were doing an inquiry about prepayment meters. And in that, you also talked about a kind of system whereby almost the electricity companies put pressure on the senior judiciary to make this process more electricity company friendly, i.e. to make it even swifter and less rigorous. Can you tell us about that?
It's an uncomfortable truth that energy companies pay to apply for these warrants, and the income stream to the court service is worth millions of pounds. And so in that sense, the energy companies are a paying client of the courts, and these changes were definitely rolled out without consultation within the magistracy. At no point was I, as an individual magistrate, given an opportunity to say whether or not I thought they were a good idea.
Kate, what do you think? What's your view of the culpability or not of magistrates in this? It sounds like a scandal to me.
It really kind of throws back to this idea of what the magistracy is for. So one of the things that came up in our research study was the fact that despite this critique, if you like, of lack of legal knowledge, most of the people in our study wanted to keep the magistracy. And when you push them as to why, they would say there was something about the human quality of it, and that there was some reservations that if it was purely decided by district judges, you would lose that. And I think there's something about the changes where you're removing the discretion of magistracies, you're removing the openness of the process that's in fact taking away what it is that lawyers value. So in the name of efficiency, of course, you have things like the single justice procedure, you have this kind of batch decision making. And you can say on the one hand, well, removing discretion is good because, legal knowledge should be more certain, we need to have certain outcomes. But I think actually, on a fundamental level, having an open justice system, having that kind of transparency and place for humanity is critical, and it's easy for that to be lost, and I think it is being lost. And I think that even the lawyers in this study who are critical of magistrates really valued that and didn't want to see that disappear.
Robin, what's your view of that?
So I remember when I applied to be a magistrate, I applied at the same time as the husband of a friend of mine. We were both asked the question, what did we think the purposes of sentencing were? And there's a legally correct answer to that in statute, which of course neither of us knew. And I gave a long, slightly rambling answer about deterrence and public protection and reparation and things like that. And my friend's husband gave a 3-word answer that the purposes of sentencing were to punish criminals. Now, both are right. They are all purposes of sentencing. But the great advantage of a bench of 3 is you bring those personalities together to have an exchange, to balance each other out, to bring those varying viewpoints. And I dare say, actually, that, we had a conversation earlier on about the efficiency and speed of lay benches versus district judges. If you were to require district judges to sit in a bench of 3, I promise you they will slow down and you will start to see less consistent decisions. That consistency, efficiency, and variability point is inherent in the fact that you have 3 people who need to get aligned on the salient facts of a case, if there's going to be a sentencing exercise, how those facts feed into that exercise, what you're going to emphasize in pronouncements. That's the system that we've chosen to have.
And I do think it's important to point out, for me, certainly, there's such a thing as justice that is too quick. We should not be too quick to convict defendants. And I think we're removing so many barriers to conviction that becomes a real problem.
And it's very interesting in your research, Kate, that of course, inevitably, the people who have taken part from England are drawing a distinction between lay benches of 3 and a district judge sitting alone. And I do think that there are lessons that the English system can learn from the Scottish system. So in Scotland, you have one lay magistrate who sits with a legal advisor. Their sentencing powers are less. They're reappointed every 5 years. They do at least 12 hours training a year. And they generally deal with a kind of narrower range of charges than English magistrates. And I do think there are pointers there for the English and Welsh system on how magistrates can do better and could perhaps regain some of the confidence that's been lost with some of the advocates appearing before us.
And I do think it's worth pointing out that in a system where things are functioning a bit better, when things are adequately funded, where people have the time and resources to go through things carefully, I think that there is more of a kind of respect and ability to incorporate things like lay benches, etc. But in a system that's absolutely on its knees, I think you can see why, in that circumstances, things like lay benches not being as competent as they could or being perceived to be that way will be much worse. It's kind of like they can't be dealt with now because things are already so bad. So I do think that context is important, and the fact that the lawyers went out of their way to say how dreadful things are and how many of them are thinking about, leaving the profession. So that does colour it.
Kate, obviously Robin left the magistracy. He resigned because he felt that his concerns were never going to be compatible with what he was doing as a magistrate. Do you think the magistracy should be able to accommodate sort of, as it were, rebels like Robin?
I think it's a very difficult position because, I'm inclined myself to think that you need that. But I think you would never be able to let that fly in a formal sense. Like, we will allow people to interpret decisions as they would like. And I think that's the great tension when it comes to involving lay people in any kind of justice system. On the one hand, you want them because they provide something different. On the other hand, the difference means perhaps a lack of consistency, slightly less certainty, which flies in the face of the values that lawyers are trained to believe are most important. So, I'd want to have secret rebels, but I don't think you could advocate for them openly.
And it's just because I don't see myself as a rebel at all. Isn't that interesting? What I wanted was reassurances. And to this day, I don't know whether all of my concerns were justified. I don't know whether I was right. And I wish I could have stayed in. In all honesty, I really regret resigning. I miss the role enormously. But there's just that lack of transparency. And I simply don't understand why courts are not streamed, and in particular why the single justice procedure is not streamed in order to make that process vastly more transparent than it currently is.
When you say streamed, do you mean available to observe online? Or
exactly. For example, with a single justice procedure, all of the technology exists and costs peanuts for that sitting to be broadcast straight to YouTube for anybody who wants to go and look at it. And I completely agree with you, by the way, Kate, that no bench, no individual magistrate can sit in court and say, I have decided not to apply this law on an individual case. You simply can't do that. But what is missing is a feedback loop from the courts to other parts of the judiciary and government to say, in the round, as a question of policy, are we sure we're doing the right thing here?
Well, that perhaps is a good note to draw matters to a close. It's been a fascinating conversation. We end these podcasts by asking each of our guests if they were in charge of the system, Lord, Lady, Chief Justice, whatever it might be, what one thing would you do in this case to improve the magistracy? Robin, let's start with you.
Genuine performance management and appraisal. The system at the moment works very, very much on time served. The longer you're a magistrate, the more responsibilities that you can accrue. And what that means is that over time, some people who do not live the kind of standards, the very actually low standards that are required of us, are able to roll along. And other people end up being disciplined for often doing quite silly things, and they end up in front of the Judicial Conduct Investigations Office. There's just something going wrong with performance management in the magistrates' court at the moment.
Okay, Kate, what about you?
I think the main thing you need funding for the whole criminal justice system. I think without the adequate funding, you can't improve things. And I think if we imagine that we can provide adequate funding so people aren't constantly putting out fires and can actually think about these broader issues, that'd be pretty important. Specific to the magistracy, you want to be able to attract people from different backgrounds. That's very difficult because it's not a particularly attractive thing to do. It's quite a difficult thing to do. So obviously you can't necessarily professionalize it, and you wouldn't want to, and you can't necessarily pay people, but you have to think of more creative ways in which you can actually recompense people and get more people to be willing to do it. I'm not quite sure how it will work, but I think that's really the only way you're going to change the fact that you have a limited pool of people who can ever afford or have the time to do it.
Rob, what about you? What would you do?
Well, I remember our very first podcast was about the single justice procedure, and it's come up once or twice since, and again today. And I'm very concerned about that, and I do think that is something that the new Justice Minister really needs to have a proper look at, whether this is dispensing justice in a way that is fair to defendants. Penelope, what about you?
As a former sitting magistrate, I'm afraid I would curb their powers, and I would say that no magistrates, or in fact district judges, should have the power to use imprisonment either for remand or for sentencing.
That's a controversial one.
Thanks, Rob, Kate and Robin. For more information about Kate's research and about Transformed Justice's extensive work on reform of the magistracy, do look at our programme notes. And for anyone who's interested in applying to be a magistrate, let's hope we haven't put you off. There are many great magistrates dedicated to serving justice. Bye.
Goodbye.
Bye.
Bye.